Great, welcome if you're just joining our webinar for this evening. I am Becky or Rebecca, and I'm going to be the chair tonight of our roundtable. We're just going to wait a few minutes just to let people join, because I know we've had a lot of interest in the event, which is very exciting. Obviously, it's an issue that a lot of us are really passionate about and have been following over the last few weeks especially. So if you're just joining us now, a massive welcome, and we'll wait a few minutes and then we'll kick off. Hi, I'm sure there's a few more people just joining us now. Welcome. This is our Young Legal Aid Lawyers virtual roundtable event where we're looking at the review on administrative law and the independent review, I should say. But I'm just going to actually post in the chat box while we're waiting for people to come in a copy of the government call for evidence so that you can have a look at that document as we're speaking tonight, because the panel, our lovely roundtable, will be commenting on the terms of that document. Oh, I think I just sent that just to. Here we go. Hopefully everybody has got that link. Welcome if you're joining us. We've got about 100 people that are with us tonight. Thank you for giving up your Wednesday evening, and I can assure you it will be worth your while. We've got an amazing lineup tonight. Our roundtable of frontline experts are going to be giving their thoughts and opinions about what we can contribute in terms of young legal aid lawyers, our evidence with the independent review on administrative law. As you know, the government has made a call for evidence, the panel has made a call for evidence, and we want to be providing evidence about our experiences on the front line. So what I will start with is just some admin, just as people are still joining us. As you can see, we're here for a Zoom roundtable event, and we have got a great panel of speakers. I'm just going to briefly introduce our speakers and ask them to give us a wave, just so you can put a name to a face. So we've got Georgia Banks from Duncan Lewis. Hi, Georgia. We've got Jessie Brennan from Bindmans. Hi, Jessie. We've got Miranda Butler from Garden Court. We've got Ollie Carter from Irwin Mitchell. We've got Lois Clifton from Simpson Miller. We've got Clare Duffy from Doughty Street. We've got Claire Hall from CPAG. We've got Mira from Garden Court North. Hi, Mira. We've got Jessica Jones from Matrix Chambers. We've got Rowan Smith. And we've got Robyn Taylor. So welcome everybody, a massive thank you to our roundtable who are here to join us tonight. I have a few apologies. You might have noticed a few blank spaces from the list, but unfortunately, it's been a time of legal aid lawyers being in the wars, I have to say. We've got Siobhan, who was supposed to be chairing, but unfortunately she isn't well. So you've got me instead. I am Becky or Rebecca, and I'm on Young Legal Aid Lawyers Committee, and I work at ATLU. So I'll do my best to not let you down, but I'm not an award winner like Siobhan. Maybe after tonight, we'll see. But anyway, we've also got some sad news that Ellery can't join us. Ellery's not very well. And also Josie had to fall off the bike. So we miss you guys. We're gutted you can't be here tonight, and we're wishing you a speedy recovery. And you're not off the hook. We still want to hear from you in terms of your evidence for the response to the call for evidence, because we know you've got great things to say. Just a little bit more housekeeping. I want to say a massive thank you to One Pump Court for hosting us tonight on Zoom. And just to remind everybody that this is a recorded event, so we'll be posting the recording on our website. So if you're missing it, don't worry, you can catch up. We also will be tweeting throughout the event, and I absolutely encourage you, if you're watching, to talk about this with your mates on social media and outside of social media. Post, and don't forget the hashtag Young Legal Aid Lawyers Virtual, YLAL Virtual, because we're passionate about this. We want people to know what's going on. And actually, this isn't something that's just relevant to the legal community. This is relevant to everyone, to the public in the UK, because as we know, judicial review, public law impacts everybody. So let's make sure that this remains on the topic of conversation. I also want to encourage people to get involved. So obviously we want to hear from our roundtable, but we also want to hear from our participants. I know that so many of you are working on the front line and you know, have day in, day out experience of public law work and the impact that has on your clients. So if you've got questions for our roundtable as the event goes on, if you've got comments, please do feed them in. And there is the question and answer function, as you should see on your screen. I will do my best to respond to these and to delegate the questions around the panel, but I'm around the roundtable. But if I miss you, I'm so sorry. Don't take it personally. We've just got a lot of people with us tonight, so it might be a little bit tricky to manage. So without further ado, I think we'll get started and we will kick off. So just by a little bit of background, so many of you will know that the government are looking at public law. They're looking at judicial review. And they've set up an independent review of administrative law. They set up a panel. You can find out who the panel members are. The government have got this. Just Google independent review on administrative law or judicial review, and you will see who the panel members are. And the panel have put out a call for evidence, as I said earlier, to the sector, but actually largely directed at local and central government. Young legal aid lawyers are going to be responding to this call for evidence. We want to give our voice, and by our, I mean all of us, in terms of the participants, the roundtable, and our wider peers in the sector, because we think it's incredibly important that actually our views and our experiences and our evidence are taken into account by this panel. And we think what we've got to say is powerful, but we now need to formulate what we're saying. And that is why we are here tonight. That's why we're having this roundtable, because we've got some absolute experts with us. I'm so excited. I feel like I'm amongst a whole lot of celebs and many practitioners that I really look up to and have heard about, and I'm sure you have as well. So I'm excited to hear their views. And sort of the way that we're looking at this is we're looking specifically at the document that the government have put out with their call for evidence, that the panel have put out with their call for evidence. And we've asked our roundtable if they want to give some comments to some of the specific things there. So without further ado, we'll get started. So if you've seen the link in the chat box, I'd ask you if you bring up that document perhaps, if you can. And we're going to be looking at straight to page 6 of that document. So this is section 1 of the questionnaire that's been sent out for the call for evidence. And it's a questionnaire at this point in section 1 specifically to government departments. Basically, what the IRAL are asking are, what is the experience of central and local government in terms of judicial review impeding the proper or effective discharge of their functions? So basically, they are asking central and local government to give evidence as how judicial review impedes their discharge of their responsibilities. And they've set out, as you'll see on that page, I'm not going to read it all out, a list of things that they're asking the central and local government departments to comment on. And I know that that some of our roundtable were particularly keen to comment on this part of the review. So I'm going to ask Claire actually if she wouldn't mind sharing with us some of her thoughts about this question. And yeah, go for it, Claire.
So my thoughts on this question. So firstly, it's quite lopsided in that it's a questionnaire only to government departments. So initiatives such as what we're doing tonight to get an NGO or practitioner's response is really important. So any organisations responding to this questionnaire shouldn't skip over section 1 and straight to section 2, which is directed at all the respondents to the questionnaire. Looking at the list, so question 1 is essentially a breakdown of many different grounds of judicial review. One ground that is noticeably missing is systemic unfairness, and that's really, in my view, what this term's reference is really targeted towards. So the chair of the panel, Fawkes, recently gave an interview in the Times in which he discussed his role on the Secretariat. He said, "Is it for judges to have great ground principles on access to justice, for example? You may have all sorts of views on funding cases, but ultimately you may think that is a matter for Parliament to decide." And there are 3 cases in which he cites in that article, which are Miller No. 2, so the prorogation case, Unison, which is the employment tribunal fees case, and then also the Supreme Court case on Gerry Adams' interment. So the real trigger for this review is systemic cases, And so when answering this question, I don't think we should get distracted just by the day-to-day JRs, but also need to make the argument for why judicial review is of benefit to all taxpayers, not just the individual claimant in the individual case, and why it serves a broader common good that is not just great grand principles, and not just for Parliament, but they are across the whole of our constitution. That's all I want to say on that.
No, thank you, Claire, thank you. And actually, just before, when we were joining the roundtable, we were speaking specifically about the article that you're talking about. And I know as well, Mira, that you had some thoughts on these questions that have been specifically directed at local and central government. Are you happy to share with us?
Yeah, so my views are kind of similar to Claire's, which is I think this question in essence tells us more about the review than the answers will tell us about judicial review. The way that the question is framed tells us what this review is really about. And I think in responding to this review, we need to be really mindful of the fact that this isn't a legalistic, dry exercise about clarifying the law. It is a politically driven attack on access to justice and the rule of law. And it goes hand in hand with government pronouncements about activist lawyers. It goes hand in hand with the Home Office writing to judges complaining that too many people are being allowed out on immigration bail. And I think when we look at the question that's directed at government departments, the answer is almost suggested. So the rule of law is listed separately from the proper and effective discharge of the central and local government functions. Now, you could say that part of the function of central and local government is to maintain the rule of law. But the way that this questionnaire is put together, the comments of Lord Folks, we are not answering an independent review. What we are doing is defending the rule of law. And I think in particular, the idea that a government department is going to own up to the fact that judicial review makes it make decisions in a certain way and make decisions carefully is something that any lawyer will be incredibly skeptical about.
Mira, I think you articulated that so well. I was just resonating with what you were saying, and I think you're right. And what really concerned me when I read this document was even the wording of the first question. I was like, why are the panel not also asking, how does judicial review help local and central government to ensure that they are discharging their legal obligations? Because I guess my experience with my clients is that actually judicial review it's helping the government do what it's supposed to do. It's helping these bodies that are supposed to follow the rules that our own government have put down. And that's what I've seen anyway. Something else that I found concerning was I feel that this is almost, this isn't looking at the root cause perhaps of maybe any stress that local or central government departments are feeling in defending litigation. Isn't the question here not, oh my goodness, why is this a problem for us? We're getting so many cases. But isn't the question, is there a reason we're getting so much litigation at this time? And I feel like it's a band-aid to the fundamental problem that if we are not resourcing central and local government to be able to adhere to the law, then of course you're going to see judicial review action. It's about assuring that these departments can work to the law. And I guess my experience on the front line is most departments, they can't discharge their duties. They're not resourced to do it. And that's why we're seeing so much litigation. However, I don't think the scope of this review is going to put forward that evidence on the questions that it's asked. So perhaps as part of this discussion, we can talk about how we can make sure that evidence is put forward before the panel so they can actually see the flip side of how more lawful decision making is happening as a result of judicial review. That was my little rant on that question. I just got fired up reading it as well. Rowan, I know you also had some comments that you wanted to make about this part of the call for evidence. Please let us know your thoughts.
Thanks. Well, just echoing everyone's comments so far. Yeah, the the kind of overall overall observation is that the questions seem to be premised on a false assumption that somehow the system's being abused by claimants. And I think that's something that we'd want to counter, like you say, with positive case studies. And the suggestion that somehow lawful decision making is optional and it's somehow discrete or separate to government functions. Surely government can't function if decisions aren't being made lawfully. So that sort of kind of robust initial response, I think is something that we'd need to make.
Thank you, Rowan. And yeah, I mean, I completely agree. And I want us to move on to the next question, because I guess I feel this question does give us a bit more scope to sort of have a more balanced view. It just asks, in light of the terms of reference, are there any improvements to the law and judicial review that you can suggest making that are not covered in your response to previous questions? So I guess it's asking what improvements could there be, as opposed to just saying why is it bad? Perhaps a little bit more openness there. I know that Louis had some thoughts on this. Can you share with us?
Yeah, sure. So it says in light of the terms of reference, and looking at the terms of reference, I think my greatest concern is the fourth term of reference, procedural reforms in relation to duty of candour, standing, time limits and right to appeal. And I think restrictions, clearly what the aim is there is to restrict kind of disclosure and tighten up limitation deadlines and channel judicial review. But rather than excluding it entirely. But in judicial review, procedure and substance are linked, and limiting procedure will limit the scope, possibly more effectively than an attempt to exclude grounds and codify judicial review. And I think this is an area that we as junior lawyers can really highlight, because as trainees, as paralegals and junior solicitors, you're really involved in disclosure, in kind of making sure the claim's issued on time and in getting the procedural points right. So I think any response we submit needs to push back on any procedural reforms. In terms of areas that I would improve, you know, I was having to think, and judicial review is relatively successful, and that's borne out in the high number of cases that settle. It's so rare in our judicial reviews that I've ever helped on or worked on that we've had to go to a final hearing, and, you know, often we don't even issue proceedings on them. Since 2016, when I started working in public law, I was just looking at the JRs I've worked on, and I think I've seen one community care judicial review go to a final hearing and a couple of age assessments, but invariably they settle. And what we deal with on a day-to-day basis is the inertia of the state and how they deny the rights and entitlements of extremely vulnerable people, which is very different from the Miller cases and kind of the big cases that this is clearly aimed at. But, you know, what we deal with day in, day out is London Borough of Lewisham say no when they should be saying yes, and we come along, threaten a judicial review, and they change their mind. So what was I, but, you know, if I could think of two areas to improve judicial review, I'd say strengthening the duty of candour to encourage disclosure at an earlier stage. It's so rare that we get, you know, full disclosure at an early stage, and cases could be dealt with at a much earlier stage if we had the disclosure necessary to give early advice. For example, we have had a client since 2016 who's gone through 2 trafficking judicial reviews and an unlawful detention claim. They've all settled, but we still don't have the disclosure that we've been requesting since 2016, and the costs we've incurred in requesting specific disclosure from the Home Office, receiving copies of documents we've already seen, like having to look through them anyway, then go back, is just incredible and frustrating to the client's case. And I don't think we would have even had to issue 3 cases if we had had the disclosure from the start. So that's the first improvement I'd suggest. The second one is access to judicial review. We all know that legal aid means regulations are so restrictive that only those well below the minimum income standard of living are able to access it. And this is a political decision, and clearly there will be a fight over the extent to which those financial barriers are justified. But when we're going to see a housing and financial crisis that will hit a far broader swathe of the public. So we need to really be shouting about legal aid being available for more people. But these improvements aren't what the government's going to want to hear, and we know the government we're up against and the political agenda that's behind this consultation. And as Mira said earlier, it's a political attack on judicial review. And I think we need to be considering, how outside of this consultation, which I imagine will be a rubber stamp job, although we should be putting in a robust response, how we're building a defence to that political attack outside of consultation. And I think that means rebuilding institutions that can defend our side and weaken the government. So it's showing solidarity with social movements and building unions. Because, I was trying my best to think of improvements, but I can't imagine them being in the final government response. Sorry for going on.
No, there were a lot of nods going on as you were speaking, so I think we're all feeling you. Georgia, did you have some comments as well?
Yeah, just to add to those comments about disclosure, a lot of my experiences with the Home Office, because a lot of what we do is immigration based, and recent experience on the charter flights particularly, which obviously are quite urgent cases. We often get them less than 5 days before the flight's scheduled. They don't have any paperwork. Even if they've been given the paperwork, they don't have it to provide to us because it's left in their accommodation after they were detained. And we ask the Home Office in pre-action letters for very specific documents, screening, interviews, medical records, fitness to fly assessments, specific things that shouldn't be very difficult to send over and would have a big impact on pre-action and their decision to oppose action and our decision to proceed with it. And even after charter flights have passed and we've still got the clients, the decision's been stayed, we've got situations like you explained, Lois, where we still don't have disclosure, and you're kind of having to beg GLD for it in the end. So yeah, we have the same kind of experience.
Thanks, Georgia. I feel like that's the experience day to day of so many practitioners that are working in immigration and detention claims and trafficking claims, and I'm sure as well in claims against local government. Ollie, did you have some comments? I saw that I know you have some good thoughts around this area.
Yeah, so I unmuted myself because what Lois was saying kind of tied in exactly to what I was going to say, mostly aimed at the next question or the next section we decided to talk about. So, I mean, she's right, and it's like hugely concerning that we have a government that wants to limit forms of accountability on public bodies, on the government, on public bodies, by doing things like cutting legal aid and restricting judicial review. And so we're often forced to make this sort of defensive or reactive case to defend what we have. But I think we do also need to take these opportunities to try and make a positive, proactive case for improvements that can be made. And we can assume the government might be keen to hear them, but let's make them to the panel, this independent, in inverted commas, panel, and push them to try and make the improvements that we suggest. And Lois spoke about legal aid and access to judicial review being a problem, and that is a huge problem. That's what I wanted to talk about today, because we know that only around 25 to 30% of people, maybe even less, are financially eligible for civil legal aid. So I think that should inform what we say about this. Obviously, legal aid is outside the scope of this review, but costs in judicial review cases aren't. And one of the biggest barriers to access to judicial review is the risk of having to pay adverse costs, the costs of a defendant if you bring a judicial review and lose. And there have been suggestions about how that can be addressed, which I can perhaps get into later. But what I wanted to say was that if you look at the call for evidence, on the first page of it, the question it asks is, does judicial review strike the right balance between enabling citizens to challenge the lawfulness of government action and allowing the executive and local authorities to carry on the business of government? Now, what I want to say is that we should say no to that question. It's already far too difficult for citizens to challenge government decisions, public body decisions, and the balance needs to be shifted in favour of the citizen against the executive. So the panel should be making recommendations to increase access to judicial review because of those difficulties in accessing legal aid, because of that adverse cost risk. And when we come to the next question, maybe I'll talk about practical suggestions we can make. So I'm conscious I don't want to just do a monologue for a long period of time. So I'll hand back now, but that's what I wanted to say after what Lois said.
Thank you. And I just think to add on that, I think the strict deadline for bringing judicial review claims, so you've obviously got a very strict limitation period, I think that also ties into the cost issue, because if somebody has got to raise funds, maybe that's through a crowdfunding source, or they're needing to find someone to act as intervener because they can't take on the cost risk, you've got such a short window to be able to get your claim out the gate, really. And I just think that's a huge check that exists on judicial review, you know, and my suggestion, which I'm sure this government will not take, is that actually that limitation is way too harsh. Especially as well when we're not, like we've talked about disclosure issues. If you don't have the documents that you need in order to show that your claim has got merit, and you're never going to get that disclosure within, you know, the 90-day, 3-month window, definitely not in my experience. I think we should move on. So if you've got the document in front of you, we're actually going to move down to question 7. We're going to skip a few questions because we think they're sort of not really that we're best placed to be bringing evidence in relation to them, and obviously we've only got a certain amount of time here today. But if we look at question 7, so this does speak about costs. Are the rules regarding costs in judicial reviews too lenient on unsuccessful parties or applied too leniently in the courts? I know, Miranda, you had some thoughts about this, and yeah, we'd love to hear from you.
Yes, I did have some thoughts, and I wanted to start by echoing what a few of the panelists have said and what Ollie said in moving on to the topic of costs, which is to look at the broader context to this review. And I just want to highlight the constitutional background here, that I think the UK is almost unique around democracies in modern times, that we have an executive that has a vast amount of power. We don't have a proper bicameral system. We don't have strong form review. The powers of the courts are already significantly weaker than countries like France or of course, we're all thinking about the US Supreme Court at the moment, and that's a stark example of how powerful courts can be in other countries. So when we're looking at what seem like quite dry procedural questions around costs, I want to start by having it firmly in mind that our government has an almost unmatched amount of constitutional power already, and therefore any watering down of judicial review is problematic in constitutional terms. But moving on to the question I was actually asked to answer, I found this question a little surprising, because something that I'm sure some of my fellow panelists have seen is increasingly some pretty politically motivated decision making, which often leads to substantial adverse costs orders against the government. And so whilst the tenor of this question is plainly geared towards effectively frightening people away from litigation through the threat of very significant costs orders, any changes that the government makes in that regard may very well actually come home to bite themselves, especially in the more expensive cases that go to trial, where the government's often unsuccessful. On the point of whether the cost of judicial review are themselves proportionate, I think I'd have 2 responses to that. Firstly, many of these claims are not damages claims. They may be related to individual liberty, they might be related to allowing someone to remain in the country. They're often about rights vindications, and without sounding cliched, that is a matter that you can't put a price tag on. Furthermore, if the costs of judicial review are disproportionate, it's because these matters are not being appropriately dealt with pre-action. I think that this question links into a number of the other questions that we've already dealt with and we'll come on to deal with. So many of my cases, so much of my income, to be frank, comes from badly made decisions that, for whatever wrong-headed reason, the government decides to defend. I'm certainly not saying I win all my cases, but you see a sufficient number of cases where the decision to defend a poor initial decision itself appears to be politically motivated, and that is a waste of public funds, quite simply. So I'd say better decision making and meaningful engagement at the pre-action stage would save a lot of money for the government, both directly and indirectly.
Thanks, Miranda. It's been really, really insightful. And I think maybe, yeah, the government should be looking at it from those eyes as well. Perhaps the cost that's incurred of judicial review perhaps could have been avoided, again, by making lawful decisions that weren't politically motivated. Robyn, I know you've also got some ideas about this. We'd love to hear your thoughts as well. Oh, you just put mute on, so now we can't hear you.
Sorry, can you hear me now? Perfect. Sorry, I'm looking at two different screens, so apologies if I look away. But I kind of fielded these questions internally at DPG as well, so this is kind of like what we've been discussing, and there have been various suggestions in relation to these two questions on costs. One of those is that perhaps different principles on cost should apply to different types of JR, and that where a matter concerns an issue of public importance, perhaps unsuccessful claimants shouldn't be penalised by an adverse costs order. Obviously there's the cost capping regime anyway that we have now, but it's something to think about in terms of sometimes people are, and I get this is exactly what the government wants to attack, but they're taking on broader public issues, and whilst obviously they have standing and they haven't, you know, they have something at stake in the claim, in order to allow people to vindicate those rights, maybe it would be better if they weren't deterred by the risk of huge adverse cost orders. The second one was that basically our kind of experiences that defendants, they don't comply with the pre-action protocol, they don't give you disclosure when they're meant to, because of their kind of inertia that we've all talked about, you end up having to issue, and they might then you might do all that work, and then they might settle just before you get interim relief or just before you get permission, and then it can be difficult to get costs. And actually one of the suggestions was that defendants who refuse to seriously engage and follow pre-action protocol or disclose important documents, there should be cost implications for that against the defendant, which should mean less claims would be issued, and it would deter then defendants from waiting until after issue before taking effective action. And I think the general consensus was that for these routine cases, if the claimant does lose, they should be ordered to pay costs in a usual way. And obviously from the defendant's perspective, most of our clients are legally aided, so, or we get a really low cost cap. So obviously they're not going to be happy with that. And then on question 8, I think the view was that the question is just a bit bizarre. Proportionate to what was the retort. And because obviously if you are successful in getting your costs and the defendant says they're unreasonable, they'll go for assessment anyway. And proportionality will be a factor then, and detailed assessment. So it is built into the system already, and it's not really clear what they're getting at, whether JR just costs a lot or it's costing public bodies a lot. We weren't really clear on the scope of that question, but we obviously can assume that they think it costs too much. and that it costs the public purse too much. And those were our kind of initial thoughts on that. So I'd be interested to see what the other panelists think.
Thank you, Robyn. For those that don't have the document in front of you, I'll just quickly read question 8. Are the costs of judicial review claims proportionate? If not, how would proportionality best be achieved? How are unmeritorious claims currently treated? How should they be treated differently? So I know, Rowan, you also had some thoughts about both question 7 and question 8. Let us know what you think.
Yeah, well, I was just thinking, while the other panelists were speaking, that if we're wondering about how to incentivize defendants not to defend claims that clearly they've got no base to defending, whether an incentive or a disincentive for doing that might be, rather than getting costs in the case if you get permission, penalise defendants for defending a permission decision when you do get permission. That could be one thing that you could build into the system. So at least the claimant would get their costs for, because after all, the application you initially make on a judicial review is about arguability. And if you get permission, why shouldn't you get your costs for winning that argument? Strikes me that might encourage more defendants to concede permission, which would quicken up the process, ultimately to fewer resources, or at least it would at least enable claimants to bank a proportion of costs, so it's not all at risk. Yeah, and then just generally, you know, the rules on legally aided claimants and adverse costs, that's already been rowed back from the previous position that effectively meant there's no chance of ever getting a cost order against you if you're legally aided, and that got watered down. And any suggestion that legally aided claimants would be at greater cost risk would undermine the whole basis of the legal aid system. And this probably feeds into the later questions about public interest standing and CCOs. I'm not sure if that's what they meant by that use of the term. It's a bit confusing to me, but again, there's already a statutory regime in place to ensure that public interest is defined by the courts and filtered out that way. So yeah, there's just some general thoughts I had.
Thanks, Rowan. I just want to hear from Mira on this, and then I'm going to move on to the next question because I'm keeping an eye on time.
Well, my views again go completely to the opposite of what this review is hoping to hear, which is I think that the rules on protective costs orders are too narrow at the moment. So I think the vast majority of people fall into a category where they don't qualify for legal aid because the means test is so low, but at the same time, they cannot afford to take on judicial review. And at the moment, to get a protective costs order, it's really very narrow. And particularly, you have to have no private interest in the case. Well, if you've suffered a massive injustice and you have a private interest in the case, you're on the kind of income which most of us are on, which means that you can't afford to bring an expensive judicial review. The court should be able to give you a protective costs order. So I actually think that's an area where the costs are not too lenient, but too difficult for normal people to access.
Absolutely. And I just wanted to say as well, before we move on, I think I wanted it to be acknowledged, or to remind the panel, that because so many JR cases settle before issue, especially if you're a legal aid claimant lawyer, and I'm sure many lawyers that are not legal aid, they may be acting on CFAs, so they're not exactly getting cash in hand. Many other departments are required to prop up the public law teams often, because if you're just getting paid a public law legal aid rate on your legal help, it's not a lot of money for these claims. And because obviously you're only issuing on so few of them, you know, costs are very important to the livelihood of the profession. And it's not about lawyers getting rich, it's about lawyers being able to do public law. And without that, of course, we've got a huge access to justice issue. So I'm interested really on I guess, us at the lower end of the profession sometimes as well. And we're not, we can say we're not getting these fat paychecks, we're in it for justice. But actually, to have our jobs, we need to be able to make sure that, you know, these legal fees can be paid. And I want to move on to question 9. So are remedies granted as a result of a successful judicial review too inflexible? If so, does the inflexibility have additional undesirable consequences? Would alternative remedies be beneficial? And I would like to ask Jessica Jones if she could give us some thoughts on this question.
Sure. I think my starting thought about this question echoes what's been said about some of the others, which is who wrote this question, what's it getting at, and what is their experience of judicial review? You know, Lord Folkes has extensive experience of judicial review, and so he must know that flexibility is absolutely inherent to judicial review. It is part of the way in which the process works. And I was reminded about a really nice quote in a Lord Reed Supreme Court judgment, Borgas, in which he says specifically, judicial review is flexible enough to deal with any of the circumstances that come before it. And that's absolutely been my experience, both in how the courts approach cases that are brought to it by way of judicial review, and then in the remedies that they grant. So if we think specifically about the remedies that courts can grant in judicial review, there are the kind of 3 traditional remedies, which is they can make a mandatory order requiring the government to do something or not to do something. They can give declaratory relief. In human rights cases, they can make a declaration of incompatibility, or they can grant damages. Between all of those different categories, I have never been in a case where the court hasn't been able to do something that's felt appropriate and that has felt tailored to the specific circumstances of the issues that my clients have been bringing to them. And sometimes the orders that they make are very specific. You know, they can tell the government they must do something, tell the government they mustn't do something. Sorry, I omitted to mention they can quash secondary legislation. And I've sometimes ended up with very detailed orders from courts that you can't get better examples of flexibly approaching the matters in hand. So just by way of example, in the Jamaica 50 case, which is obviously one that the government has been very angry about, in that case, Lady Justice Simler gave an order as interim relief that specified exactly what the government was not allowed to do. They were not allowed to deport on a flight that was due to leave at or around 6:30 a.m. on the 11th of February anyone who they were not sure had a SIM card in a phone that allowed them to have access to lawyers for at least the period of time that the government's own guidance requires detainees to have had access to lawyers for before they can be deported. And I'm interested in the experiences of colleagues on this panel, because how can that be too inflexible? And in fact, slightly contrary to some of the other questions here, it seems to me it might be in the government's interest if it was more inflexible, not less inflexible. But I think I find it very flexible, and so I can't think of ways that flexibility as an alteration would amend or improve the process, really.
There's a question from Jeremy specifically on flexibility in the chat box. I'm just going to read that. And Jess, if you feel like you want to answer that, or anyone else wants to jump in, I think you might have covered some of it already in what you've said, to be honest, but I think I'm eager to hear others' views. So in terms of time limits, what's the panel's view on flexibility? As it stands, the judge can give permission for a JR case to be brought out of time. A different area, but similar example for this that can apply is Al-Hamed 2020. Is IRLI considering limiting this and restricting judges' discretion, do we think? Has anyone got any thoughts on limits? Go for it, Jess.
Yeah, I mean, my experience is that courts are reticent to extend the time limit, but that there are very many cases that I'm involved in which we might call rolling judicial review cases, where there's a kind of continuing breach or a continuing unlawfulness. And in those cases, I found the courts to be reasonably open-minded about periods of time passing since, you know, an initial breach, and being open-minded to that. I don't know the extent to which the independent review itself is looking at that. I presume that is one of the amendments, as discussed, that they might be looking at when they talk about streamlining things. You know, in planning cases, one has to bring planning case. There's a shorter period of time. I think it's 30 days. I don't do planning law.
6 weeks.
Yeah. 6 weeks. Thanks, Rowan. You know, with people on the panel have already spoken about the difficulty that the existing time limit can impose on people, particularly where in that 3-month time you've got to go through the pre-action protocol, you've got to try and get the disclosure that you need to settle your grounds and to bring your claim. At the same time, I'm not someone who thinks an open-ended time limit would be beneficial, because we are here balancing up different interests, and it's in the interest of all of us for the executive to be able to get on and do its job as well. And the 3-minute time limit is intended to strike the balance properly, so that there is finality in public law decision making, and so that institutions can move on and enact the things that they've decided to do. And I think that is important as well. So for my part, sometimes the judicial review time limit can feel harsh and can produce what feels like unjust effects. But broadly speaking, I tend to think it currently strikes a reasonable balance.
Thanks, Jessica. Lois, did you have some comments on this as well? I saw your mic.
Yeah, I mean, the only time I've ever seen a judge use that discretion is when we had a case where we thought the local authority hadn't done an assessment when they were supposed to have done one. So we asked them to do one and they refused. And then we ended up issuing, and then they presented an assessment that we were out of time to challenge. But basically the judge allowed us to challenge that assessment out of time because nobody had seen it, including the client. And in that case, it was really useful to be allowed to issue and to be allowed to proceed, even though technically we were out of time. But yeah, I mean, no, like good judicial review lawyer is just requesting an extension for the sake of it. But yeah, it's a good point in that question that may be one of the things that they do consider limiting, is the ability of a judge to use that discretion.
Thank you. So I acknowledge that there's a few questions that have come up, and also Ollie's posted some really great things in the chat. So I want to save some time at the end just for him to be able to share some comments on that, because I think it is actually really important on the cost issue. So we'll just keep moving with the questions, but we'll do a little bit of a recap at the end to cover that and the other questions that have come through. Also, quickly, Claire, I know that you had some thoughts specifically around remedies, and yeah, we'd like to hear from you as well.
So I entirely agree with Jessica that there's plenty of flexibility in the system, and that remedies are quite often withheld by the court because they prejudice administration. And so that begs the question what this question is actually getting at, and whether it's actually aimed at building less flexibility into the system. And back in 2015, when the Criminal Justice and Courts Act was still going through Parliament, one of the aspects that there was a lot of debate around was whether courts should not be able to quash or void a decision, or should not have to automatically quash or void a decision. And in the Act, the court is required, so it doesn't have discretion, it's required to refuse relief if the outcome would not be different absent the unlawful conduct of the defendant, and that's both at permission and merit stage. And so we've already had greater inflexibility built into the system that benefits or places more weight on the administration and effective governance than it does on claimants. So I wonder if it's going back to making, back to some of the reforms that were debated in 2015 and now going to raise their head. I mean, one of the interesting things about this paper is there are no specific proposals. So this is phase one, and hopefully there'll be concrete proposals that go out to consultation after Christmas that can have more robust and more targeted responses on in due course.
Absolutely, and I guess it's something we're yet to see how transparent this process is going to be, right? It's yet to see, you know, how this evidence is going to be presented to us and to the public once the panel have gathered it. So I think we'll all be watching closely to monitor that. I want to move on to question 10. So if you've got the document in front of you, that's where you're going to, and if not, I'll read it out. So, what more can be done by the decision maker or the claimant to minimise the need to proceed with judicial review? And I would like to ask Clare Hall if she could give us some comments about this and her experiences and practice of what this could look like.
Hi, yeah, so I think this sort of similar to how Becky picked up right at the beginning of the discussion, that some of the questions don't necessarily look at the underlying reasons for why judicial review is needed, and you mentioned under-resourcing. I think this is another one where you really need to look at what's going on outside of judicial review. So at CPAG we see a lot of the same issues coming up sometimes for a whole load of different claimants, and they'll come into us via welfare rights advisors. And the way we deal with that is we have like a bank of template pre-action protocol letters that advisors can use to get like a quick result for their client without even involving a lawyer. But these issues that are coming up are sort of basic failures to apply the law as it is. It's not, it's like bad decision making essentially. But the question is, what happens after they get that quick result for their client using that letter? Because in the letter we might say, can you go away and, you know, change this bit of guidance that's clearly confusing decision makers, or maybe it might be something like, you need to change this online application form that asks for a bit of information that's unlawful to ask for. But if there's no coordination between, say, like the legal team who are resolving those early stage judicial reviews within the government department with the operational side, then what happens is the same issues come up over and over again, and eventually if they're not getting resolved at a systemic level, then we'll end up bringing a proceeding with a claim the whole way. So yeah, I think I've mainly focused there on what the decision makers could do more of, I guess, rather than claimants. But I suppose as claimant lawyers, we can also think like, you know, can you throw a line in your pre-action protocol letter that says change this guidance, as well as sorting it out for my specific client? So those were my thoughts on that.
Claire, I'm 100% with you in terms of the same causes of action having to be brought multiple times on the same issue. And I think the breakdown within both local and central government around, I think we've all found, if you're dealing with, say, someone on the front line, perhaps the housing officer, and then your case gets then sort of referred to the legal team, it can get resolved really quickly. And I'm not blaming that specific housing officer, but I'm blaming an internal process where I don't think there's adequate training. I also think there's a really fast turnover of staff, perhaps of, you know, those frontline people that are making decisions. So perhaps even if training is being given, you know, it's redundant within 6 months when someone new is in the post. And so there was a question actually that sort of also relates to what you were saying about empowering people, you know, with the work that CPAC have done with pre-action templates. So Sarah has said that in some research that she did, she found at least 1/3 of claimants in civil non-immigration judicial review claims were litigants in person. And I guess that speaks to a few things we've talked about: access to justice, both that's in terms of costs and perhaps also access to a lawyer. And Sarah's asked if the panel have experience of litigants in person in judicial review, and could it be an increase in unrepresented litigation is in itself causing delays in the process? Would anyone like to comment on that?
So I do have a small amount of experience of my time representing the defendant, but having claimants against us who are litigants in person, and definitely from personal experience, it delays things. It basically makes you representing both sides because you have to explain all the procedures. But apart from the kind of isolated incidents I've seen, I'm not aware of a kind of general increase, but obviously I assume there is data on it. I think more of the problem is simply a restriction of access to justice rather than so many more litigants in person kind of flooding the system. Potentially immigration, I think that might be a field where there's more, but from my personal experience, I haven't seen many, but mostly a claimant lawyer, so I wouldn't be seeing the Home Office against on the other side.
Jessie, I know you had some thoughts as well around what more can be done around minimising the need to proceed with judicial review in the first place. Do you just want to carry on? And
yeah, sure. So without wanting to scream, make lawful decisions, I think there are some other things that you can kind of unpick. And the way I see it is kind of like before the decision is made and after the decision is made. Before the decision is made, exactly echoing training, adequate guidance, and internal checks within decision-making bodies. So why is it that one Home Office caseworker makes a decision and it's not checked by someone senior? Could they build in some independent reviews early on that would just simply prevent some of these awful decisions? So say for age assessments, why is it that local councils make those decisions? Can they build in an external review mechanism that would just get away, so like a lot of these cases? And also on the kind of wider policy decisions that are more likely to get to actual challenge, consult early, consult properly, and admittedly there'll always be decisions that need to be challenged, but I think that would cut out a lot, and I think it's important for us to put that to in our response, and then also look at ourselves. I'm sure we're definitely not blameless in potentially not writing full pre-action letters, not making sure you're actually checking your client's facts, checking and actually really pushing for documents before you proceed. And then potentially what we sometimes do is just delay issuing a bit by agreeing with the other side obviously you can't agree to extend the time limit, but you can agree to issue protectively and then engage in proper pre-action correspondence, and that's actually always worked out really well. You get the defendant to agree, and then you have just time. You don't have this immediate straight into full grounds, and then everyone's really invested and they've done all their work, and so they're kind of digging in more. And then kind of after the decision has kind of been made, I think for decision makers, getting specialist advice early on, don't keep it in-house, send it out and get some fresh eyes on it. Decision makers granting interim relief, as in so just giving us what we want, straight away. So all of the kind of unlawful detention claims that I run, you just issue, you get interim relief, and then the whole thing goes away, and it's just completely pointless. Like if they just gave you the interim relief, you could deal with the unlawfulness of the detention at a kind of steady pace, but you wouldn't need to have issued, and you wouldn't have wasted everybody's time, including the courts, arguing about it. And I think it's the same with removal cases. Again, if they're presented with a kind of arguable case, as Rowan said, don't dispute permission. Let's get rid of the urgency in the situation, and then let's discuss the kind of underlying legal basis of the arguments. Without wishing to go through a kind of dream list of what I wish decision makers and JRs would be, but yeah, that's it for me.
Thanks, Jessie. Straight over to you, Mira.
I think a good example of where a decision maker defendant could have done something differently is the case of Jordan Begley, which was an inquest where the IPCC judicially reviewed itself because the IPCC had decided that the officers in that case had no case to answer after what the jury decided in that inquest was a use of force that was unreasonable, and where in essence the person who was killed was tasered by the police, and there were other uses of force against him as well. Now, in that case, the IPCC had to judicially review itself because, and I know that this will have happened because it happens in almost every inquest case where the IPCC does a report after an unlawful killing. The IPCC will have created a report, or now as they call themselves the IOPC, which will have had massive failings in it, which will have automatically and reflexively taken the position of the officers and gone out of its way to ensure that no criticism was directed at the officers. They will have ignored all of the family's pleas for a review of that. They will have ignored the family's perspective, and they will have taken procedural steps, which meant that the officers were given an easier procedural ride than they should have been. And that isn't an issue of guidance. It's not an issue of training. It's an institutional issue of bias in decision-making and disrespect for the rights of people. And that creates a situation where people are encouraged to make decisions not following procedure, not following guidance, but to get a certain outcome because of the culture of the institution. And when it comes to inquests, we find this problem time and time and time again, whether it's the IOPC, whether it's the prison ombudsman, whether it's the organization itself, defending and defending and defending, rather than actually having some candor in the first place when things go wrong, putting their hands up and saying, okay, this is how we're going to make a decision, this is how we are going to properly investigate ourselves. And it's a political and a cultural issue.
And I think what you're talking about, Mira, just to me, like screams as why we need to strive to protect judicial review as our mechanism of holding this to account. Because otherwise, I think we're in quite a scary place. And even, in the last 6 months, it couldn't be more topical for me. It couldn't be more topical for me, I guess, the fears I see in terms of institutionalized cultures, positions, and political agendas that go against the rule of law and that actually are a huge threat to our country and to the individuals in this country. Man, I think we're in a scary space, and it's so important that we are protecting the mechanism we have that is our main defense, really. Miranda, as well, I know you've got some comments about this, and I'd love to hear from you.
Well, I can only echo what everyone's already said. Just on the point that you were making just then, I noted in the comments that someone had referred to the guidance, the judge over your shoulder, which is designed to encourage civil servants to think about the threat of judicial review continually. And without breaching any confidences, my partner is a civil servant. And I find it very interesting to hear from him the flip side of JR and what it's like on the inside. And his experience, limited though it is of decision makers very much trying to do their best, and people being very mindful of the Civil Service Code of Conduct and of the threat of judicial review being a very significant one that is taken seriously by many civil servants. But conversely, I think the problem that he's identified, and the problem that frankly I see in my own cases, is that if there is a political top-down, on often ministerial level, desire to reach a certain outcome, then even the best civil servants in the world cannot fulfill their obligation to their minister and fulfill the instructions that they're receiving, whilst also complying with the guidance that they're given. And I think that's where a lot of this tension comes from.
Georgia, do you want to come in here as well?
Yeah, so it was a point I was going to make anyway, but I feel like it leads quite on well from Miranda. Obviously dealing with the Home Office at the moment, everything that we're doing is highly politicised, and it often feels like we lack a lot of engagement at the pre-action stage, because sometimes it appears that the Home Office factor more political expediency into their decision making and how a case is going to be perceived in the media than they are actually thinking about the legal issues. And And I think that quite a good example of that is the Jamaica 50 case, again, that we worked on with Jessica, and how she explained a little bit about what happened in that case. But it was quite apparent that the Home Office had breached its Chapter 60 policy for removals in the 5-day time period. And can you still hear me? Sorry, I didn't know if it, yeah. It was quite clear that something had gone wrong, and the Home Office acknowledged that, and they put things to the court that kind of tried to get them out of it. And they pursued that case to the very end, going out of hours to the Court of Appeal, despite the fact that it was quite apparent that there had been an issue and the judges weren't going to budge. And that case actually seemed to be one of the triggers for the reason that we're here now for this review. I think there was a Telegraph article the same day or the next day, which quoted Boris Johnson and Dominic Cummings being really angry with the judicial review process. And it seemed that maybe it's quite an obvious point, but that they're only annoyed at the judicial review process when it doesn't work for them. And actually, the reality of the Jamaica 50 case was that it was a really serious access to justice point, which is one of the most fundamental constitutional rights. But and that intervention, the judicial intervention, stopped them from breaching their own policy. But that could have been stopped if they'd just engaged at the very beginning. But ultimately, it's more beneficial for them, for a judge to refuse it, and for them to then blame the courts or the lawyers, as they do now, than it is for them to take responsibility at the beginning and do the right thing at the pre-action stage. So often it kind of feels like it's getting over that political hurdle, but which I don't know how we can do, but it would be interesting to hear other people's opinions on that as well.
Yeah, it's really interesting, I think, seeing how the rule of law in general and judicial review is kind of seen as, it can be okay. It's like almost a popularity contest, I feel, in the way that often it can get portrayed by politicians and the media. Like, we love it if it's, somebody or something we love, and if not, no, it's terrible. And I guess, thank goodness, the law isn't a popularity contest, right? It's impartial, and that's, again, a fundamental principle, that so anybody can access the protections in the rule of law. I want to go straight on to hear from Robyn about question 11. So I'm going to read the question, and then I'm going to ask you, Robyn, to dive in. So question 11, do you have any experience of settlement prior to trial? Do you have experience of settlement at the door of court? If so, how often does this occur? If this happens often, why do you think this is so?
Thank you. Yeah, we have lots of experience of settlement prior to trial. So there are certain points where settlement usually is more likely to happen. So once you've issued, if you've been granted interim relief, especially in your kind of more run-of-the-mill asylum support type cases, often the Home Office will settle at that stage. Or if on other cases it's at permission, like once you've got permission. And then in terms of settling at the door, I think sometimes even once you've got permission with some public bodies, it feels like they haven't actually applied their minds to the case yet. They haven't instructed counsel, and it's been in the hands of people who potentially a bit closer to the case, and so they're quite dogged about fighting it. And then you can see a point where they've clearly got external advice and they've decided to settle on that basis. I think our collective experience was that there wasn't, we didn't feel that JRs were more likely to settle in civil litigation, but they'll have the stats potentially on some of this as well. So they'll be aware of how much they're settling. I would have thought, the government at least.
Thanks, Robyn. Jessica, do you want to tell us a little bit about your experience of this as well? And then we'll go straight to Claire. And then I just want to wrap up with some comments from Ollie about the things he posted earlier in the chat and just some questions that have come up as well.
Great, thanks, Becky. In my experience, which is that many judicial review claims settle before they go to final hearing, I think there are really three categories of cases in which my experience is the government or a local council or any executive body is most likely to settle. The first is the rarest, I suppose, which is when you sort of feel like there's some kind of cost benefit analysis going on. So my experience of that has most frequently been in things like challenges to unlawful cautions against police constabularies, where they will defend in pre-action in pre-action letters in order to sort of in the hopes that you'll go away. But once you actually get to issuing, and particularly if you get permission, my experience is that they tend to fold at that point and retake the decision or quash the caution or whatever you were asking for. And I don't know exactly the thinking that's gone on there, but my sense of it has always been that they're thinking actually weighing up the likelihood of us winning this versus the cost of instructing people to take it to trial. It's actually more in our interest to just do our own review now and retake the decision. The second is in the kinds of cases Robyn was talking about, the kind of asylum support cases, community care cases. And that just feels like a category of cases in which the experience of being a claimant lawyer is endlessly coming up against the politics of austerity. And so what happens is that your case is not important because you are dealing with a group of people in the local council or in the Home Office or wherever who are overworked and under-resourced. And until there is the threat of litigation or actually issued proceedings, you don't get up the top of the pile for them to really consider what's going on and to get that external advice or to really just get out the documents that are necessary to review the lawfulness of the decision, apply their minds to what needs to happen and retake a decision. That's the most common, I think, of the categories in which there's pre-hearing settlement. And then the third category that I've had some experience of is when it feels very much like a case is being settled to avoid embarrassment. So I have had that recently, this summer, in a case where we were pushing in pre-action correspondence about a TACT prisoner, so a prisoner under the Terrorism Act, and they were refusing to disclose to us the documents that we needed to bring a prison JR, refusing, and actually in the context of the duty of candour conversation earlier, they just weren't complying with the duty of candour, but it's so hard to get them to do it. And eventually we ended up writing a letter in which we threatened a pre-action disclosure application. And immediately on that, they never made the disclosure, but they changed their position. We got the relief that we wanted without the proceedings going ahead. And I'm sure that's because there was something they didn't want to disclose to us. And I've had a case like that with Robyn, not on disclosure, but probably the most astonishing settlement case in my career was that we had got to the day of the hearing. So they had gone all the way through skeleton arguments. We pitch up at court. I was being led by Karen Monaghan QC. She is on her feet from 10:30 until 1. Defendant's barrister's due to take over in the afternoon, and over lunch they make a settlement offer. And what's the reason at that late stage? Our only sense of what was going on there was they were trying to avoid a judgment. They saw that they were going to lose and they didn't want it in a judgment because there might be something embarrassing in a judgment that came out against them. So those, I mean, that third category, again, much rarer than the second category, which is the kind of proliferation of cases that settle are those austerity related ones, where you're just coming up against a paucity of resources. But yeah, in my experience, it happens often, and litigation or the threat of litigation, getting the government to change its mind is often as successful as actually going through to final hearing in a case.
So I can just add quickly to what Jessica was saying there, because actually I think she's already covered what I was going to say largely about duty of candour and disclosure and the importance and relevance of that in settlement. As an anecdotal example, at CPAG, they've seen the upper tribunal, when it's acting in its judicial review capacity, take perhaps a more bolshy approach to ordering disclosure, and that has on at least one occasion prompted settlement as a result of it, because the defendant didn't want to disclose whatever it was for whatever reason. So yeah, just would echo Jessica's thoughts on that.
Thanks, Claire, and thank you all so much for your contributions to all of these questions, because I feel like there's so much to talk about. In fact, we could talk all day. 90 minutes is not enough, because there's just so much content and so much, I think, collective experience in the group and with the colleagues that we work with around the ins and outs of this. But Ollie, I rudely cut you off on talking about costs, and I feel like I'm at a dinner party and I'm trying to speak to everyone at the table. It's very overwhelming. But I'd love to, if we could go back to questions 7 and 8, and then we were talking about proportionality and costs in judicial review. And Ollie, I know you've got some thoughts, so if we could hear from you on that, please.
Yeah, sure. I don't think you cut me off. I think I cut myself off to give other people time. But yeah, so if you've been following the group chat, I've shared 2 blog posts that I was going to talk about by Tom Hickman QC. So I'd recommend that people read those, because they're blog posts from 2017 where they're titled Public Law's Disgrace. And he said the most important issue in public law, and the disgrace in the title of the blogs, is that the vast majority of the population have no access to judicial review in any meaningful sense. This is because of the rule that if a claim is lost, the claimant must pay the cost of the defendant. And I think that's right. You know, earlier I said around 25% of people are eligible for legal aid. That leaves a huge majority of the population who aren't eligible for civil legal aid. And if they don't have tens of thousands of pounds sitting in their bank account waiting to bring a judicial review case to defend their rights, then they are effectively cut off from public law, from judicial review. And there are recommendations in the second blog, well, the first and second blog, about what can be done about this. I mentioned them in the chat as well. Read more about it on the blog. The first is qualified one-way cost shifting, which basically reverses the rule, the usual rule about costs, so that the general rule is that defendant public bodies wouldn't be able to recover their costs against unsuccessful claimants. There would be exceptions to that. But that was introduced for personal injury cases in April 2013. It was recommended for judicial review cases by Lord Justice Jackson, but wasn't introduced for judicial review. And as a second best or backup option to that, Tom Hickman talks about the Aarhus cost regime for environmental cases, which basically fixes the potential risk of adverse costs for a claimant to £5,000 because of rules in an EU directive about environmental claims not being prohibitively expensive. And someone like Rowan, who does environmental cases, might know more about that, but that has also been recommended as a potential way of solving this adverse costs barrier to claimants. So I think, as sort of young legal aid lawyers, people concerned about access to justice, this should be one of our focuses in responding to the review and thinking about how it can be used as a way to improve access to judicial review rather than to limit it. And I think we also just need to make it very clear in our responses that any restrictions the panel proposes for judicial review will have the effect of unlawful conduct by public bodies going uncorrected. And if they're going to further restrict judicial review or recommend that the government further restricts judicial review, they shouldn't be allowed to shirk away from the effect of that, being that unlawful state conduct will go uncorrected and not unpunished, as I said. So that's all I wanted to say. Thanks, Becky.
That's okay. While I've got you, I'm going to target you with a question that's come through, because I know you've done a lot of work in this area. So one of our attendees has asked, what are the solutions to increasing access to justice? How would the government finance more people being able to access legal aid? Sorry, I put you on the spot, and everyone else is welcome to chip in too, but I'm sure you've got some thoughts on that question.
Yeah, well, I mean, we know, obviously, as young legal aid lawyers, that the legal aid budget has been cut hugely since 2012 with the Legal Aid Sentencing and Punishment of Offenders Act. So, huge savings have been made by the government, and that has restricted access to justice hugely. So, it needs investment. It needs investment in access to justice as a public good. And, how does the government finance that? The same way it finances other important public spending from tax, obviously. So, I'm not saying it's easy, and I'm not saying we have a government that wants to increase access to justice or increase spending on legal aid, to allow people to bring cases against the government. But I think that's what we should be arguing for still.
Has anyone else got any ideas on access to justice? Lois, do you want to go for it?
Yeah, I mean, I agree with Ollie. I mean, it's a political decision on what they spend money on. And I think that, like all the issues that we've discussed tonight, we also need to come up with political solutions, because as much as I think lawyers like to talk about the law being kind of an impartial arbiter, it's not. It's made by people in power, and any gains that we have is gained through struggle and through winning it. It's not, and we can never take that right for granted. So I think that widening access to justice is a political argument that we just need to win, because otherwise the government isn't going to give it by being nice, which is what we've seen over the past, since LASPO, really. But yeah, they can find the money for it, they just don't want to.
Yeah, because I think something, when I was reading, I guess, both the terms of reference for the review and obviously the areas that the panel are seeking evidence on, is the big gap in evidence that as a sector, it's really hard for us to produce. But that is actually how many judicial review claims should be brought that aren't, often because of access to justice issues that we've discussed a lot tonight. But even I find at ATLU, we run an advice line, and a lot of the questions I get come through, a lot of people don't know that the decision that has been made is unlawful. People don't understand, and who would? You don't, in the area that you're not familiar with. So I think actually the government, maybe I'm saying this, but from my own experience in the trafficking world, I'm like, you could have faced a lot more judicial review than you've had, because there has been a heck of a lot of unlawful decision making going on, and a heck of a lot of independent people that have had their rights breached. It's very concerning, but how do we show that evidence? How do we put that information forward? We won't know the amount of people that haven't accessed justice because they wouldn't have been able to reach us. So that brings me to two questions that I kind of want to finish up on, and I really welcome posts from attendees as well in the box, and even if we can't say it, we've seen it, and it's helpful because it will feed into our response as well as young legal aid lawyers. But in terms of this specific evidence call, what do you think we should focus on as our group of the sector? Can I hear from the panel on that?
Okay. I think as the junior end, the kind of early settlement cases and like our bread and butter of community care, asylum support, all of these things that the terms of reference don't look like they want to hear are the things that we need to make them hear, because they'll be the effect of any changes. The kind of big political judicial reviews will probably still happen when there's a will, there's a way. But what's important to us is that kind of data set of really good kind of political examples of, parents whose children have SEN and haven't been able to get the support, or like the bedroom that they need, or these kind of, lovely Daily Mail stories that we need to get them to read to understand the real impact. And I was kind of thinking about like the data that might be available, and I think there obviously the courts does keep kind of data of cases going through the system, what types of cases, etc. But I don't know whether I don't keep data on my own cases, but I wonder if the legal aid agency might have data on settled cases, because obviously when we bill files, we have to put outcome codes on them, and those outcome codes confirm the outcome. So how many successful, that's how our KPIs are managed. But I wonder if it's worth trying to kind of dig into that to see if we can find something that evidences what we say, which is when you have a lawyer, you send a good pre-action letter, like things do result, and it's only the threat of judicial review that allows that to happen. Because if the threat wasn't there, what would we do? Nothing. So yeah, that's my kind of thought.
Just to follow on from Jessie, I entirely agree. What we need is data. So what the government has and what different departments can do in response to question one is go down each line and provide a stat for the number of cases they have. And that's not the same level that's published online. Rebecca, you were saying that we don't know how many cases don't get to the courts. Well, we have a some idea of how many cases don't get to court, because we know in looking at the Ministry of Justice stats that in 2013, 13,141 cases were lodged, and by 2019 you're down to 1,636. So that's suggesting that restrictions and funding have significantly reduce the number of cases that are getting into the court. I don't think the drop in numbers has been because there's been a massive increase in the quality of decision making, much more likely to do with the lack of access to the courts themselves. One thing that I think we as organisations, so chambers, charities, solicitors, can do is look at our own stats and provide how many cases settle at a certain stage, and what kind of grounds they are. If we can get that kind of quantitative data that once you have all the responses lined up together can create some balance in the statistics, I think that would be really helpful. And in addition to that, what we do have that is powerful is the qualitative data. So the stories, the personal stories that show how judicial review improved decision making in general, and also how they improve the lives of the individual claimants themselves. And that's something, again, that we can get by surveying our own organisations and putting in a response to this call.
So true, Claire, absolutely. I think that's really powerful information that we should gather. And sorry, I should clarify, I was meaning the cases that don't even get to a lawyer for the pre-action stage. So all those ones that should be referred for a public lawyer, but that referral never happens for various reasons. But you're right, I think that the information is there, and perhaps a coordinated effort through us and the wider sector to make sure that we're putting that forward. And also I should just say, we've had to say a quick goodbye to Lois, who's left us, but we've got 5 minutes left. And I also wanted to ask, I guess, thoughts on outside of this evidence gathering exercise. I know we've seen some comments come through and some questions around this is a political issue. How do we respond politically outside the scope of this evidence gathering? Has anybody got any ideas? Mira?
Well, I think it's important to remember this isn't the first time that the government have tried to attack judicial review. We had Chris Grayling in 2014, a favourite among many legal aid lawyers, who tried to push through a bill that was not dissimilar to what I think was going to come through this review. That was defeated in the Lords by Lord Panic and other people who actually had experience of the law, who actually cared about the rule of law. And I think what's really important at this stage is for us to build a broad coalition of people who are in positions of power as well as ourselves, and to start early and consistently lobbying the MPs, people in the House of Lords, and parliamentarians who I think actually do care about the rule of law, even if they are usually not exactly on the right side, on the same side as us. I think a lot of people are persuadable on this issue, and I think we need to start early, and I think we need to raise people's concerns so that when the bill does come through, which I think is a done deal as a result of this review, when the bill does come to Parliament, we have people ready to oppose it.
Can I just jump in? So I think making use of kind of NGOs and charities that have policy teams and have those kind of existing connections with, you know, the kind of all the MPs and parliamentary groups, I think will be really important, because as a sector, the legal aid world is not particularly well versed at campaigning on its behalf. I think partly because we're also overworked, that we simply don't have enough time to do that. So I think kind of building the connection. Going to make a plug for Legal Sector Workers United. That is a union for everyone in the legal sector, and definitely campaigning on issues like this. So I think there are kind of bodies that do exist that we can try and build on. But I think, yeah, connecting with existing frameworks will be really important to make our jobs easier, but to also kind of widen our reach.
Thanks, Jessie. We have got a minute to go, so I'm going to have to wrap us up there, but I want to start by saying a massive thank you to everyone that has come and been a part of our roundtable. I think It's been really encouraging and insightful to hear your experiences, your wealth of knowledge, and even your passion on this issue. And I also want to say thank you to our participants and our Young Legal Aid Lawyer members who are out there every day sending the pre-action letters and representing our clients and representing the individuals in public law, because it's often a tireless and thankless task. But man, we thank you and we appreciate what you're doing and we want to hear from you. So on that note, I'm going to give a plug for our survey that's going to come out, and we're going to be sending it out to our members. I mean, please share it wider in your groups. If you know of individuals that aren't a part of our membership, invite them. They're very welcome. But we want to hear your feedback, and so we can put together a really robust response to this call for evidence. I just want to again say a massive thank you to One Pump Court for having us or hosting us on Zoom, and remind people as well that this has been recorded so you can catch up later. And also make sure that you tweet about what's happened tonight. Stay involved in this issue. I think this is going to be a longer fight than just a response to evidence, but it's encouraging to me that there are many people that are up for it, as well as I am. So a massive thank you. Have a lovely Wednesday evening and enjoy the rest of your week. Goodbye, everybody.